Yeah, both of them. One of them here. Also have Mr. L back here as well.
All right. This is the Eddie Banks L matter. And 3A0225-485. Mr. Banks L, you want to come forward?
You really wish to engage me?
Yes, I do. You come grab a seat, or you want to welcome to stand up? We'll come to you closer to the mic.
No. See, this is a arena of honorable men. So if y'all can run y'all court the way you wish, allow me the same respect, and everything is copacetic.
All right. This is the Eddie Banks matter, Eddie Banks L matter, 3A0225-485. This was on, there was previously a competency evaluation ordered. There was some non-compliance with that, but ultimately, most recently on December 4th, a new out-of-custody competency evaluation was ordered, and that's the last status that I have. All right, anything to add, Mr. Smith?
I've been assigned as Mr. L Bank's attorney, but it still doesn't talk.
Well, Mr. Banks L, what we're looking at is the evaluation hasn't been done yet. Last time we talked about how it's court ordered, and the preference was for you to do it out of custody instead of in custody. We're still in that same.
What don't you understand about free will and free sanctity of mind?
Well, I understand that. We've talked about this before, that you're ordered to do the evaluation. You have a couple of options. You can do it out of custody, or you can do it in custody. You agreed last time that you're out of custody. There are changes to that agreement?
Yeah, there have been changes.
Okay.
After you finish doing what you're doing, so
I'm done.
you're done?
Yes.
So is it my turn? Okay, welcome to go. All right, I'm giving notice of case number 24-201-08931. Since you don't want to listen to me, Honorable, you don't want to listen to documents, I have here a statement that's been published. Oh, can I give copies? My bad. I don't want to scare y'all because I'm an honorable man. I'm not trying to hurt anybody, but I got to get my point across.
Offer of proof.
Yes, it's an offer of proof.
Tell us what you want to give to everybody.
This is a declaration of independence, letting my political will be known. You don't have any interest, and I'm not a beneficiary to these proceedings. You just want to tap into my blood and my resources and drain me. I'm not accepting it. So I've instituted civil proceedings against you. Now, Miss Megan, I would like to get her name. You should be served within a week. I'm gonna add him, add her. Y'all don't want to listen?
Did you do this last time?
No. This has been public.
New?
Yeah, this is something new. So can I give you all a copy?
I'll defer to you whether you're okay with
There you go. Thanks. Summon. Oh, it's public. It's not a problem for the city and for yourself. All right. So the next step, if you want to continue, what I'll do is every state official who wishes to continue, when I bring this federal matter, there will be no excuses, no reliance on, I didn't know, I didn't understand. You tried to rape this man's individual free will. I'm not having it. So that's all I have to say. You can continue all as you please, but I'm telling you, you're not free from the consequences.
Mr. Banks L.
No, I'm pretty much finished, but I'll be respectful.
Still leaves us where we're at before. I understand if you want to bring proceedings, you have a right to do that, right? But where it leaves us still is you're ordered to do this competency evaluation.
No one has the authority to order me to do anything.
Well,
For what reason? What proof?
So the court's ordered it. It's there in a court order. And again, the situation that you're in is you have to either engage in that out of custody, which you agreed to last time, Or what we can do is find that you're not compliant with the conditions of release, amend the bail order, and then you'll have to engage in that evaluation in custody. It is still one moment, it is still very much my preference that you engage that out of custody. I don't think that there's any reason that you need to be in custody to do the evaluation, but one of the reasons that you would have to do it in custody is if you refuse to do it out of custody.
Tell me, why do I have to see your people for an evaluation?
Well, that's something, a conversation you can have with Mr. Smith, and we talked a little bit about.
No, it has to be.
One moment, Mr. Banks, I'll give you a chance. So, you have the right to present evidence about the competency, the status of competency if there's a disagreement about the report. You have to engage in the evaluation that's been ordered.
Okay, so who's here to compel you to perform according to my trust res?
Well, if you're asking about who else could assist you in getting an alternative evaluation,
No. I'll do this. I'll do this. Yeah, I forgot. I've filed this too. Let me make this a part
I
of
think
it.
that's already been, I can kind of see it from here. I think that's already been filed in court, so let me.
No, not this. You know what it is?
Well, I see the seal, so I guess it looks a little bit.
Yeah, because my court runs on the same seal that your. No, that's not the same.
All right, you can bring it up.
This is a choice of law, living trust law. Nah, I just created that, buddy.
Well, it's great for me.
Okay. Only the flag and the seal. So we're going to see. Because we're going to enforce contracts. You want to enforce yours on me? We're going to see. We're going to see if the Republic and the law is real.
All right. So, Mr. Banksell, the decision that we're talking about today, you're ordered to engage in the out of custody evaluation. One second. What we're looking at is, I haven't had any information, and you remember what this was like. I assume you remember what this was like several months ago, that the evaluation wasn't engaged in, and the conditions of bail were met. Recall that?
Keep creating evidence against yourself, man. It's fine.
All right, well, certainly all of that's in the court record. Whether you want to agree with recalling those events or not. But we're at the position where if we're going to do that again, then the conditions of release simply need to be amended and we need to be back in custody that you're engaging that evaluation.
Okay.
Last time we were here, you agreed under what you described as duress,
Okay.
that you would engage in that evaluation out of custody. And I
Okay.
want to make sure you're still on that same page, that you're
Okay.
agreeing, although it's something you don't want to do, and you're.
And it's going to be public. The evaluation has to be public. Because I don't trust you private individuals, because look at what you're doing.
So, Mr. Smith, part of that order is he can engage in the evaluation and be there, and then really that's between however that evaluation goes between, between you, between Mr. Smith, and it's between the evaluator. So, that's something, I can't make a decision about whether it's public or not. This is your private information. So, you're gonna have to leave it up to the evaluator. If you want to somehow publicize this or have somebody looking at it, that's your decision in combination with the evaluator, okay?
It's my turn now?
Yep.
Okay. So, again, I need to assess why it has to be your people, because I've experienced this before. I've already had one independent, and you are rejecting that. So tell me why this specifically has to be your people. Because hold on. Because your person can tell me to my face and write down this and that and the third, and then report and say, oh, he's suffering from psychotic disorder, NOS, not otherwise specified, yada, yada, yada. So that's the problem. So if we can get an independent party, then yeah, I will consider it. But no, I'm not seeing your people.
Thanks. You said that you were going to get your own private evaluation.
And I provided it for the
You were
court.
going to use that instead, and the court said that was fine, but you haven't done that yet.
What do you mean? I provided the proof.
Proof of what?
Mental evaluation.
When?
The last time we were in court. You don't have it
I
now?
wanted a new one.
Who wanted a new one?
We need one that's contemporary. A couple of things. One is, you talked before about some of the other experiences you had. I want to be clear again, that this is not any sort of restoration evaluation. It's not sending any sort of order of restoration. It's not any order that requires medication. Nothing about a blood draw, anything like that.
Can you give me 48 hours to inspect all paperwork, all contracts that is supporting the transaction?
One second. Let me finish. We'll get back to that. And all this is speaking of something. There's no treatment, no medication, nothing. Okay, so I want to be clear about this evaluation. The authority is the statute that provides that Washington State Health Services can provide these evaluations by court order. You are welcome to submit one. Dr. Smith has talked to you about that. The court filed in public. I think in the past, gone to the court, not filed certain copies of the files. They're all there. Where I'm left is something that you just said, is you will not engage in this evaluation.
Because I don't have a reason why. Why?
Because you're ordered to do it out of custody.
Who has the order? Tell me what reason, what authority does that?
Mr. Banksdale, this is.
That's all you have to tell me is where the authority comes from.
Mr. Banksdale, we've gone over this. If you'd like to copy that out of custody order, that order of evaluation, I can give you that. And it goes over the The problem is, if we leave here, or not leave here, if we can't get to the point where you agree that you'll engage, even if it's under duress and something that you don't want to do in this out of custody evaluation, the only option that I have is to amend the conditions of release, set bail, and then you'll engage in it in custody.
I've already given my declaration of political separation. You're free to do whatever. Notice has been put in the living trust for protection with the Sheriff's Department, with the U.S. Marshals, and the Police Department. So that makes their departments liable. So whatever orders, paperwork you want to push through, if they want to put themselves on the line to defend you, then so be it. But I have made my will as a man. I'm a reasonable man, non-violent. I don't talk. But what you're trying to do, what you're doing to compel me to do something that I do not wish to do as an ordinary man, that's unacceptable, man. That enrages me. I'm willing to call mutual combat since we can't settle it on paper. Let's settle it like men.
All right, this is your final opportunity. I'm going to engage in the out of custody evaluation that's ordered.
My political will has been made known publicly.
What's the current conditions of release set at?
Go ahead, man. Do your will. Oh, I'll stay and get it on because this is live on Facebook anyway. We're going to see.
All right. Yeah, please. So I'm going to call. We have an officer here. I'm amending the conditions for bail.
Man.
Previously ordered.
I'm gone. I'm gone.
Bail's going to be forfeited.
I'm gone.
I'm setting bail right now. You have $200,000.
$200,000. Wow.
Mr. Banksell, you've had the opportunity to engage in this out of custody evaluation multiple times. You're not following the conditions.
So you're going to start, okay.
I'm setting bail, your bail is.
Nah. See,
Mr. Banksell, the opportunity is over, unfortunately. Your bail, your bond is being forfeited.
All right.
It's being set in about $200,000.
Yeah. Well, that's a crime. That's for the public. Hey.
Welcome to stay here.
No, sir. You've been served a summons. If you go and do that, come on. I'm ready to go, man. I'm ready to go. I ain't playing that shit. $200,000. $200,000 to have me. That's one of them right there. Look at her. She was on the case too. Fucking fraud. $200,000 gonna put me in jail.
By the end of this hearing, one thing becomes painfully clear. This case stopped being about a competency evaluation a long time ago. What viewers just witnessed was a complete courtroom collapse driven by escalating sovereign citizen rhetoric, refusal to follow lawful orders, threats against judicial authority, and behavior that ultimately convinced the court the defendant could no longer remain free pending proceedings. The judge repeatedly tried to keep the hearing focused. She explained the options clearly. She offered the defendant the opportunity to complete the evaluation outside custody. She gave warnings. She remained calm through interruptions, accusations, and bizarre legal theories. But the defendant kept pushing further and further, and once he openly suggested mutual combat against the judge, the entire legal landscape changed instantly. That's the part many sovereign citizens fail to understand. Real courts are not internet debate forums. There are real consequences for threats, disruptions, contemptuous conduct, and refusal to comply with court orders. The most ironic part? The defendant spent the entire hearing talking about freedom and sovereignty, only to end up facing a massive bond increase and possible additional charges because of his own behavior in court. If you found this courtroom meltdown as unbelievable as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, sovereign citizen fails, and real legal chaos caught on camera.